Good morning, everyone. We are here at Rosen Injury Law, and I'm here with fantastic attorney Loune-Djenia Askew, and she is with Askew Associates, and we're going to be talking about her practice areas in wills, trusts, and trying to or helping her clients avoid probate. So tell everyone a little bit about yourself, your name, your law practice, and where you're located.
Well, my name is Loune-Djenia Askew, and my firm's name is Askew Associates, PA, and we're located in Lauderdale Lakes, Florida.
Listen, tell everyone what are your practice areas? What do you focus on?
So our practice areas include business law, real estate law, estate planning such as wills and trusts, and immigration and civil litigation.
Tell us, how is it that you got into law?
So believe it or not, I've actually wanted to be an attorney since I was about 9 years old. So I knew from an early age that this was the career path for me.
And where did you go to law school?
I went to FIU Law in Miami, Florida. Go Golden Panthers.
And so when did you decide that you wanted to get into the wills, trusts, immigration areas of law? What was it about that drove you to have that passion?
Honestly, it was my very last year of law school. I only took wills and trusts because one of my mentors recommended it, and it was one of my favorite courses. I did very well, and ever since then, I knew that I needed to help educate the community on asset protection.
Asset protection is so important for our clients and for Loune-Djenia's clients. Tell everyone, why is it so important for people to have an asset protection plan in place?
The first thing that we want to talk about is avoiding probate. I'm not sure if anyone has been following up with the recent death of the Black Panther star. Well, his probate was just finalized, and a quarter of his asset went to probate court fees as well as attorney's fees. And those are the types of issues that I want to help clients avoid. Not only are we trying to avoid the cost of probate, we're also trying to help clients avoid creditors as well.
Loune-Djenia, tell everyone what is probate and why it's important for people to try to avoid probate.
So probate is when the family members who are left behind after an individual passes away have to now go to court to take ownership and legal title to the property that the individual, which we call the descendant, left behind. And the reason you want to avoid probate is the tremendous court fees and attorney's fees that you incur when you have to go through this process. Not only is it difficult on the grieving family who does not really want to go to court when they're having to grieve a family member, it's also very cost intensive and reduces the assets and the value of that estate that the decedent left behind.
And so typically if a person has a will, like a last will, and they're going to be devising property, money, their assets to beneficiaries, members of their family. What are some ways that you're able to help a client avoid having those assets go into the estate and be subject to creditors collecting money from those assets?
That's a very good question. One of the things that the community does not really understand is a will does not avoid probate. All that a will does is it is a written document that tells the court exactly how you want to divide your property. So ultimately, you are not avoiding probate by just writing a will. What can help you avoid probate is by creating a trust, which is setting up a mechanism where title is already transferred over, legal title to your property is already transferred over before you pass away. That way, you're not passing away and leaving the title attached to you alone, which is the ultimate reason why you have to go to probate.
And these are so important to know, for people to know, especially when they're planning out their futures, they're planning out for their families, their children, and their beneficiaries. What happens if someone has, let's say, a bunch of credit card debt, or they have maybe mortgage debt or some other debt, and they pass away and they don't have this plan in place? What happens to their assets?
So their assets will be significantly reduced based on the creditors. Creditors have right even after you pass away. So if you leave your assets unprotected, where now they're having to be probated through court, the court will notify the creditors that this is what this individual has left behind, and they will basically resolve those debts and reduce your overall estate, which ultimately reduces how much your beneficiaries are able to inherit from you.
Yeah, so imagine that. If let's just say you have $25,000 in assets when you pass away, and that money goes into the estate, that money becomes subject to creditors, and those creditors can come after the money before the family members get the funds. Is that kind of an accurate representation of what happens when money goes into the estate?
Yes, that's exactly correct. And not only are the creditors are going to have, in a sense, first dibs, the attorney's fees are going to have first dibs. So, the attorney that your family member has to hire to now represent them in court, that attorney is going to have to be paid for their services, the court fees that are associated. So it's just a matter of trying to avoid this happening to your loved ones when you're, have gone away.
And other than trusts, I've heard that life insurance policies, they may be a good mechanism to avoid money going into the estate, like purchasing a whole life insurance policy. Have you heard that before?
Definitely, life insurance policies are one of the best ways to transfer asset and avoid probate. I'm so happy you asked that question, Attorney Rosen. And one of the things that we want to make sure, though, is when you have the life insurance policy in place, you want to name a beneficiary, and you want to make sure you are naming a beneficiary that is still alive. You'll be surprised. Some people name beneficiaries, and the beneficiaries, for some reason or another, end up passing away before them. If that is the situation, you now have left the life insurance policy to be probated. So the proper planning is to have the life insurance policy and to make sure you're keeping your beneficiaries up to date as well.
I've also heard of people having a whole life insurance policy where the beneficiary actually is a trust. Have you heard of that before?
Yes, and I love this question. This is a good segue into why the trust is so important. A lot of people do not understand that a trust could hold multiple assets, including a life insurance policy. So in that example, the beneficiary would not be an individual. It would be the trust you've already created. That way, whoever is also now named in the trust as a beneficiary, all of those beneficiaries would inherit based on that life insurance policy.
Asset protection is one of the most important topics. It's a hot topic right now to make sure that you're protecting your personal assets so that you don't get, if you're involved in a lawsuit or if something happens, that your assets are protected. Do you help people in setting up plans to protect their assets in case they get sued?
So this is a very great question, especially with the trust. There are so many mechanisms in place to avoid creditors having access to your assets and protecting your family members ultimately, because if you have, for example, what we call a spendthrift provision in your trust, your creditors are not able to now come against those assets because they are protected for your beneficiaries. So these are all things to consider, whether it be creditors because there's a lawsuit or creditors because of a credit card company. You want to make sure you have the mechanism like a trust, whether it's an irrevocable trust or a spendthrift trust. You have these mechanisms in place to avoid creditors have access to those assets.
So I've been told in Florida that it's important to have or hold assets if you're married in something called tenants by the entirety. What is tenants by the entirety, and why is that important for asset protection?
Tenants by the entirety typically only applies in the context of husband and wife. But the alternative that you can do is hold assets in what we call joint tenants with rights of survivorship. That way, someone else automatically inherits legal title to that property upon your passing away, and you don't have to now go probate that asset. That's ultimately what we want to avoid. We want to avoid people passing away with only their name as the legal title holder of any asset, whether it be a vehicle or even jewelry, because ultimately that's also an asset that can be passed down.
So those are two concepts to remember: joint tenants with survivorship or rights of survivorship, which means that you hold the asset with somebody else, and when you pass away, it automatically gets passed to that person and doesn't go into the estate. Is that a fair statement?
Yes, that's exactly correct.
And then as far as tenants by the entirety, what I've heard is unique about tenants by the entirety is that if you hold an asset with your spouse and you create that account at the same time with your spouse, if you get sued because of something you did, a creditor can't touch that asset because it's not yours. It's you and someone else's in the entirety. So can you explain that concept as far as avoiding a judgment if you hold those assets and tenants by the entirety?
Exactly. This is a great example of protection when you have a spouse, especially in regards to homestead, for example, when it comes to your real property, which is your primary residence in Florida. We have the homestead law that protects us in a similar way. So now if we have an asset, which is tenants by the entirety, husband and wife, a creditor cannot, for example, a husband's creditor cannot come against that property because guess what? That property is owned jointly with their spouse. So unless that creditor shows that both husband and wife agreed to this debt together, as in both of them are subject to this debt and they have that common creditor together, that creditor of the individual wife or the individual husband cannot come against that asset that's owned as tenants by the entirety.
How do you feel about people if they have the funds purchasing umbrella or excess insurance policies to help protect their assets? How do you feel about that?
So I'm not an insurance expert, but I do believe in buying insurance for asset protection, whether it be supplemental insurance like short-term disability to protect your income, those type of policies. Those things are going to ultimately help you promote generational wealth in your family. You don't want to put yourself in a position where your income or your assets could be interrupted. And so the plans that are available to you, the options that you're able to afford, get them. Even when it comes to car insurance policies, whether you're going to, increase your limits or get, uninsured motorists, all of those things are great in regards to asset protection because guess what? Your income is an asset too.
Absolutely. Listen, if you're in an accident, you want to have good car insurance in place. That insurance company will defend you if someone sues you. It will also allow assets that if there's a judgment against you for, let's say, $50,000 or $70,000, if you have a $100,000 insurance policy, that will cover all the damages and none of those damages will come out of your personal assets. So that's important to have good car insurance in place. Call your car insurance company, Geico, State Farm, and make sure you have a good policy in place. It's worth the extra premium to protect your personal assets. So now we're going to talk about what are the different types of trusts that you can set up to help with asset protection. So tell everyone, what are some of the different types of trusts that you advise clients to get?
We definitely have the option of the revocable trust. That way, if someone wants to establish a trust while they are still alive and also be a beneficiary of that trust, which means they have access to those assets while they're still alive, but once they pass away, they have the named beneficiaries that will inherit upon their passing. That is a great way to set up a trust. Only caveat is, unless you have a spendthrift provision in that trust, it's not going to help avoid creditors as best as an irrevocable trust. An irrevocable trust is a trust that you can create during your life. However, there are mechanisms in place to avoid revoking that trust, which is basically canceling the trust. Versus the revocable trust, you can cancel it while you're still alive, but it's not going to avoid creditors such as the irrevocable trust. The other trust that I see a lot of people set up when it comes to giving away for charity, there's charitable purpose trust. There's also pet trust. I know there's a lot of pet lovers out there. You can set up a trust so that your pet is taken care of upon your passing. We have even something called a testamentary trust. That one I don't recommend as much because it would still have to go through probate. That trust is created within a will. So there's other options there that are available. We can always talk about the different options that you can do when it comes to setting up a trust.
So tell everybody, what is a revocable trust?
A revocable trust, also known as an inter vivos trust, is a trust that someone creates while they are still living, and they can also name themselves as a beneficiary so that they are able to access those assets while they're alive, but they also have named beneficiaries that will inherit those assets upon their passing.
Will a revocable trust help their beneficiaries avoid the funds going into probate?
Yes. So the revocable trust will avoid probate. However, the caveat with the revocable trust, unless you have an additional mechanism in place, such as a spendthrift provision, will not avoid creditors. That is the main difference between that and something else called a irrevocable trust.
So tell everyone, what is the difference between an irrevocable trust and a revocable trust?
So an irrevocable trust, the main difference between that and the revocable trust is the irrevocable trust cannot be canceled by what we call the settlor, which is who is putting the assets into the trust. What that does is help protect beneficiaries from creditors because you're showing the creditors that you no longer have control of those assets versus the revocable trust, which you are able to cancel while you are still alive, shows the creditors you have control over those assets. So what they think is they can now access those assets.
I've heard this before. I thought it was interesting, but explain to everybody, what is a pet trust?
So a pet trust is very interesting in that the state allows pet lovers and pet parents to create trusts so that when they're passed away, their pets could be taken care of. So they create the trust specifically for their pets. It's basically for the life of the pet, and it will make sure that those animals are taken care of once they've passed away.
All right, so we are here with Loune-Djenia Askew, and she is with Askew Associates. Tell everyone how they can get in touch with you to talk about wills, trusts, probate, and asset protection.
So you can definitely contact us by calling 754-234-6018. We also have our website and Instagram, Askew Law PA. And we also have our email address, which is info@askew.lawpa.com.
So for all your questions on wills, trusts, estate, asset protection, reach out to Loune-Djenia. She is an incredible resource. She can give you guidance and help for yourself, for your family, and for your beneficiaries.